Here's where things get very fun. Did you know you can sanction an attorney? Attorneys are usually very much like sitting ducks, just waiting to get it. Oftentimes, there's usually this great illusion of what an attorney is, what they're capable of, or even for that matter, anyone, not just attorneys. But you can move to sanction the court, which is usually the acting judge, to basically compensate you or the court itself some monies, or to prevent them from doing certain things. It's really a form of equitable injunction in a way. And usually when this is done, it should be paired up with a move to strike. So a sanction is basically saying, hey, stop this man or woman from doing this because of this reason. And usually when it comes to officers of the court, like attorneys, that reason is usually based on barrarty, fraudulent conveyance of language, which is codified in 8 U.S.C. subsection 1001, and vexatious litigation, which another terminology for that in your state law and other federal statutes is simulation of legal process. So that will be part of the exhibits that you will add to this. And within the move to strike their previous documents, you would not necessarily make reference to the move for sanction, because if there is a fatal error in your move to sanction them, which is to, say, hey, you're wasting the court's time and you're wasting my time, and you've been making the same repetitive argument without proof of standing or capacity. You don't qualify for hearsay exemptions. You didn't swear an oath to your documents, so it cannot be admissible as fact or truth of the matter. And because of that, it's vexatious litigation. Or you're taking case, and attorneys do this a lot. They make reference to case laws, and when you really begin to look into those case laws, you realize it has nothing, absolutely nothing to do with the matter at hand, because they know most people don't read their case laws. And the little trick they do is, when they construct their papers, they will put a little asterisk next to certain words, or put a little bit of exponential numbers, and then they'll say, well, plaintiff claim should be dismissed because he hasn't stated the claim upon which relief can be granted. And after that sentence, they will put a little small number 1 on top of it, and at the bottom of the page there'll be a little line, and then there'll be a number 1 which will make reference to a case law. And they're basically making reference to a case law. And usually they do that because most people omit simple things like that. Most people overlook it. Most people's attention span is bad. And when most people do see it clearly on its face, they don't really look into the case laws. And when you begin to look into these case laws, this stare decisis that they're making reference to, you realize shit has nothing to do with what they're talking about. So that's vexatious litigation right there. That's simulation legal process. Things that purports to be true, but in truth it's not. You deliver it, you've signed it, and you put it into public record. You're simulating legal process. You're simulating something that's not real as though it is. So those are the reasons why you move to sanction. But in summary, listed in Rule 11. Now, there's a little loophole that they have put in on their behalf to assist them in this, and it is in the first section. It's regarding them swearing to documents for it to be admissible. It doesn't clearly say if they don't swear to it, it's admissible, but it kind of indirectly makes reference to it. And here it is. Rule 11, signing pleadings, motion, and other papers, representation to the court, sanctions, which we'll be talking about. But it is extremely important for you to understand this first part, comprehend, and be savvy to it as to what it really means and how, because this right here, believe it or not, will be their affirmative defense when you move to sanction. This right here is their affirmative defense. They've given you what you can do to kick their ass right here, but right before that, they give themselves a way out, and there's a way that you can annul all this. So it goes on to say signature. Every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. Now when it says by at least, every pleading must be signed by at least one attorney of record, meaning usually there can be a whole firm and there will be 2 or 3 attorneys representing one defendant, or if you bringing a suit against more than one entity, whether it's natural or juristic or whatever it is, you would have more than one attorneys, and they will usually designate one leading attorney or a quote-unquote fourth person who can sign on behalf of the rest. So the rest just leave, they usually don't sign it, they just leave it blank, and one just signs on behalf of the rest. So that's what this is making reference to. And then the second sentence says, the paper must state the signer's address, email address, and telephone number. Is how they gain jurisdiction. Unless a rule or statute, and also this part right here on a side note where it reference that they put their address, email, all that. This usually is used as a replacement for notice of appearance for attorneys. And in the past, even I've made that mistake to think that if they don't do a form of notice of appearance, then they can't begin to do their bullshit. So just keep that in mind. Don't let that fool you. This moment they put any pleading in and they put their address and email and their phone number, that is a form of appearance. Nonetheless, it goes on to say, unless a rule or statute specifically states otherwise, keep this part in mind, which is a simulation of legal process. A pleading need not be verified or accompanied by an affidavit. This part is where they put a loophole for themselves. But in other cases, they don't even qualify under hearsay exceptions. They just start talking a bunch of trash. And then at the end, they don't do a declaration on the penalty of perjury or an unsworn declaration at 28 U.S.C. 1746. And this is their way out. They're saying that pleading need not be verified, meaning a witness, a notary, or accompanied by an affidavit. An affidavit is you swearing to that document and having it verified. Those two things is what makes an affidavit. So they're putting this loophole to say, hey, look, you don't even have to have a witness. You don't have to swear to it unless a rule or statute specifically states otherwise. Those rule or statute are the rule of evidence and the unsworn declaration. Sworn declarations exist for the sole purpose of you not swearing directly to the document, but still attesting to its originality and that it's true and correct, which makes it admissible, which links to the rules of evidence. So don't be fooled. It gives you the exception here, which is those things we've spoken about. But at the end, because the last thing mentioned is usually what the mind remembers the most. It's just one of the flaws and deficiencies in the human mind as we currently use it. So whoever reads this one simple sentence, they usually forget this first part, which says unless a rule or statute specifically states otherwise. And they keep in mind that a pleading need not be verified or accompanied by an affidavit. And they will use this once you begin to sanction them. So keep this in mind and whip out the law and kick their ass with it. Then it goes on to say the court must strike, and it's telling you when you do a sanction, you move to strike. There are different types of motions. You gotta move to strike, because if you're saying, hey, based on what this man or woman has done in the past, sanction them because something is wrong with that. Say, tell them to pay this amount. Tell them to stop doing it. If they allow that and say, yeah, you know what, you're right, then that leaves an open door for you to strike those previous things because it is material fraud. It is vexatious litigation upon the court. It is a court's waste time. And that's one of the things you would bring up as a cause for sanction. It's a waste of court's time. It's a waste of your time and resource. Simulation of legal process. fraudulent conveyance of language, etc. Another way you can prove fraudulent conveyance of language is if there's been a previous order stating what's going on so far and they just nitpick certain parts and omit the rest. That's fraudulent conveyance of language right there. So the court must strike an unsigned paper unless they must strike an unsigned paper. Unsigned. They're not talking about verifying, not just unsigned. But they're letting you know that, see, they do double speak. You have to keep that in mind. Meaning they're telling you indirectly that once you sanction, move to strike other things. But then they're using a little magic trick whereby when you talk to someone, you do a bunch of other stuff with your body language to distract them from the substance of it. It's a form of hypnosis that they're doing on a piece of paper right here. They're making reference to other things when in truth they just previously spoke about affidavits and the basic things that makes pleadings admissible as evidence. At the same time, they're letting you know, look, if you do a move to sanction, you better move to strike too, or else you're just waiving it. The court must strike an unsigned paper, and they're talking about something else, unsigned paper. But you use your intelligence and figure out the deficiency and why they're not doing what they're doing. If you've put in Translate versus Pagliaro because they've not put in any affidavit that the court can consider as qualifying them as a real party of interest, statement of counsel is insufficient, whether written or an oral argument for summary judgment. And that summary judgment is not just limited to the formal summary judgment where there's no dispute as to material fact. It can be anything that they put in. You bring that up. You make that claim. You state that claim that relief can be granted upon you. The court must strike an unsigned paper unless the omission is promptly corrected after being called to the attorney's party's attention. Due process. One thing that usually must be done before you sanction it, to actually give the sanction weight, is to put notices of barrarty. So you will put in the middle of everything, once they usually say you're the plaintiff, the first thing they will do is slap you with a motion to dismiss based on 12b6. So once they do that, you rebut it accordingly. You preserve the right that you're not waiving your right to, to bring a proper claim by entertaining theirs, and you're doing it for the sole purpose of removing presumptions that they're a real party of interest. That will be your main basis of responding to them. And then along with that, you put in a notice of barrarty. First notice, you volunteer, blah, blah, blah. You mention their name. You make it very clear that they're volunteers in the matter. Now, that's you actually doing the quote unquote administrative process on them right then and there inside the court case as it's going on. And then when they do their response or rebuttal, if the case drags on long enough, all you need to do is that notice of barrarty to so-and-so, volunteer so-and-so, 3 times. Once you do it that 3rd time, you move for sanction. The law clerk that signs on behalf of that acting judge to reduce the workload, trust me, they peep these things. Those subtleties, those notices of barrarty, they notice it. So, moving on. Representation to the court. By presenting to the court a pleading, written motion or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or a represented party certifies that to the best the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstance. Meaning, by virtue of you doing these things that we're about to talk about, it is presumed that what you've put down is being certified to the best of your knowledge and belief. And then you're certifying it based on you doing these following things. Some cases put it out there directly, the verbiage itself, that I hereby certify, declare, or swear, or take the following oath that the following documents are true to the best of my knowledge. But you can put that directly, just the verbiage. If you don't put that verbiage, it is presumed by that by you doing these following things, it's the same thing as you certifying to the best of your knowledge and belief. And these things are, it has not been presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. These lists will be part of the cause of you moving for the sanctions. So they're given the answer and everything you need to put in your move to sanction. They're giving it to you right there. Whenever any attorney put any vexatious litigation in, it's for an improper purpose. They haven't proven their standing capacity. They're not putting any evidence in that qualifies under a hearsay exemption that the court shouldn't turn a blind eye to. Then bring maxims of law and maxims of evidence, if you have any. They're harassing you with the documents. It's causing unnecessary delay for the remedy that you seek to be granted, because that acting judge or that law clerk signing on behalf and creating all those memorandum on behalf of that acting judge, they will look at the attorney's paper as though it's normal and as though they have the right to do so, unless you say something. So you have to bring it up right from the start. And that the fact that it is needlessly increasing the cost of litigation. These would be your reasons to move for sanction. Keep it in mind. 2. The claim, defense, and other legal contentions are warranted by existing laws or by non-frivolous arguments for extending, modifying, or reversing existing law, or for establishing new law. Remember, these lists are what's required to be the same thing as you certifying the truthfulness and to the best of your knowledge and belief. But keep in mind that these are the opposite of these will be the tools that you use as a reason for sanction. They're telling you without telling you. Then when you move to sanction, your reasons will be the fact that it's an unnecessary delay, it is needless increase in cost of litigation. Why? Because none of what they're saying has been sworn to, and it doesn't qualify under hearsay exemption. And it's for an improper purpose at this stage in time. And that their contentions, according to existing law, which you will bring in a simulation legal process, fraudulent conveyance of language, are frivolous arguments. And guess what attorneys title their papers? Arguments. Because it extends, modifies, and reverses those existing laws. Or they're trying to create their own new laws without substantive evidence. Simple as that. 3rd, the factual contentions have evidentiary support. In your case, when you move to sanction, you say the non-factual contentions do not have evidentiary support, or if specifically so identified, will likely have evidentiary support. Oftentimes, shit they bring in is not likely to have evidentiary support. So you mentioned that after a reasonable opportunity for further investigation or discovery. 4. The denial of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on belief or lack of information. You would move the opposite of this, meaning anything that they brought in, you deny the fact that it's factual and there's no evidence that it is reasonably based on belief of any information, because they don't have first-hand knowledge. So believe it or not, they gave you 4 extremely important tools for you to use to back up your move for sanction. Just read this and basically flip it the opposite way, because that will back up the sanction. That is it right there. They give it to you straight up. If you read it without using multifaceted thinking, you would just read it as, oh, they're just saying one thing, which is that whenever you put a paperwork in, if you do these things, it is automatically certified as being the best of your knowledge and belief, or that if you directly use the verbiage that it's the best of your knowledge and belief, then it fits this criteria, then you're contending or creating a presumption that everything here is proper for the purpose, is based on factual allegations, and is based on evidence, and that it is not frivolous. That's what you would think, but in truth, they're giving it to you that, hey, the opposite of this is how you move for sanction, or else they would have specifically created saying nothing is stopping them from taking sanctions and putting it in all the way in Rule 56, where summary judgment or Rule 60 something or the appendix or supplementary rules. They could have done that. So they are really speaking to you without speaking to you. So pay attention. These will be part of the reasons you use to back up your sanction. I keep repeating that so that it's very clear. Now the juicy part. Sanction. In general, if after notice and reasonable opportunity to respond, the court determines that Rule 11B, what we've just read, see how it connects, has been violated. Remember I was talking about first notice of Barrarty, second notice of Barrarty, third. That is it right there. That is what they're talking about when they say if after notice and reasonable opportunity to respond. That is it right there. You can do this so-called quote-unquote administrative process as the case is going on inside the case. Yes, you can do it outside of the court, but the one thing most people may not realize, some people know this, but some people don't, is that thing they call administrative process, you can do it before, during, and after any court case. And before, during, after a court case can be done outside that court case or inside that court case itself. And that is it right there. They're telling you, they're speaking to you. After notice and reasonable opportunity to respond, the court determines that Rule 11B has been violated. And keep in mind, everything that you put in will be based on affidavit. If you don't swear an oath to it that is true to the best of your knowledge and belief, you declare that is true to the best of your knowledge and belief under penalty of perjury of laws of the United States or the United States of America. Whatever it is you want to do, just declare that it's true and correct. And those would be the notices of Barrarty, which is the reasonable opportunity to respond. And then you pair that up with Translate versus Pagliaro. Then you deny and rebut theirs. So you shut their shit down and then bring yours up, which is the reasonable opportunity to respond. And they will never respond to something like that. Never. They will never respond to it. That is perfect because it's a setup. Like an alley-oop, somebody has to throw that thing up there and the other man has to dunk it. The court determines that Rule 11B has been violated. The court may impose an appropriate sanction on any attorney if, after notice and reasonable opportunity to respond, the court determines that Rule 11B has been violated. The court may impose an appropriate sanction. Now we'll go over what this appropriate sanction is. The court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is reasonable for the violation. Absent exceptional circumstance, a law firm must be held jointly responsible for a violation committed by its partner, associates, or employee. Right there. All that bullshit attorneys do when they talk a bunch of trash, they're hitting you with a 12v6, and you now, presuming you know what you're doing and you're coming right. Just keep in mind, their job is to argue. An argument is barrature. Barrature basically means the creation of an unnecessary argument, which delay remedy. And guess what? They basically lay it out here for you. They define what barratry, vexatious litigation, simulation of legal process, and fraudulent conveyance of language is. Right here, just within these little short things, right here. This is a summary of it right here. They give it to you in a nutshell. And then they tell you, yo, you better show a reasonable opportunity that you've provided to them to respond to these things, these claims. And then after that, you better move to sanction them. In the process of that, you better move to strike all the other documents that has a similitude with all these things that's causing you to move for sanction against them. They're telling it to you. They're giving it to you. Motion for sanction. A motion for sanction must be made separately. A motion for sanctions must be made separately. Must be made separately from any of the motions. Remember we mentioned about motion to strike being made separately from motion to sanction? From any of the motions, I must describe the specific conduct that allegedly violated Rule 11b. Those specific conducts would be the example that we gave earlier regarding simulation legal process using uncompletely related case laws, the fact that they have no standing capacity, they didn't swear an affidavit to it without hearsay exemption, etc., etc. There may be more that you find, many more. The motion must be served under Rule 5, the basic way you serve people, service of process. But it must not be filed or be presented to the court if the challenged paper, claim, defense, contentions, or denial is withdrawn or appropriately corrected within 21 days after service or within another time which the court sets. Meaning if they correct their error, there's no need for you to file it, because the whole purpose of you bringing it up is because they fucked up. Keep in mind, if you don't bring this up and you don't move to sanction them, no one is going to, they're just going to keep on going on like it's all right and it's cool. Even if the acting judge and his law clerks assigned on his or her behalf sees it, they're not going to say anything. Your rights are yours to enforce. It's not anyone else's responsibility to speak up for you. The moment they do that, you are considered wards of the court, ward of the state, inferior, a minor, you're dead in the head, mind and spirit, and you have no right. And when they start to speak up for you, they're going to do whatever they want for you, because they're going to start doing parents betrayal. The attorney is going to basically hand your life over. Gives you the time limit. If warranted, the court may award to the prevailing party the reasonable expense, including attorney's fees incurred for the motion. These reasonable expense also include loss of consortium. Loss of consortium. Meaning, because they've been doing all this crap on the court record that ought not to have been done in the first place, you've lost time with your loved ones, you've lost compassion that you're supposed to be giving to your loved ones, whether it be your girlfriend, your mom, your friend, your colleague that you're very close to, your sister, your brother. So long as that other party that is suffering is your lack of emotional compassion with them. Even with sex. Literally, it sounds funny, but look up the word loss of consortium. Sexual companion too. So long as they can bring an affidavit into the court that's saying, yep, I did suffer the loss of this. So because just make sure it's not too much. They'll be claiming $50,000 for that. It's not reasonable. Just saying. So unless there are other things tied to that, but it's not up to me to explain that to you. On the court's initiative, and also if you had previously put on those notice of barratries, and let them know you need to rebut it within, really you can give them any period of time, but I will usually go by because usually, especially when you're dealing with federal jurisdiction, because this is federal rules of civic procedure, they're usually more formal. There is usually more formality. So what that formality entails is the acting judge will say, all right, the plaintiff, you have put in a complaint, and the defendant or counsel on behalf of the defendant, which is attorneys, have put in a motion to dismiss. Now the plaintiff has this amount of time to respond. Say it's the 1st of January. Plaintiff has until the 20th of January to respond to the motion to dismiss, and the counsel for the defendants has until the 15th of February to respond to plaintiff's response. Based on that time period and that formality, you give them a specific period of time to respond to that notice of barrarty. You can make it 3 days, you can make it exactly the amount of time limit that they have to respond. But usually, I want to make it as much as 21 days, but if you want, you can. So that's based on how you want to move in the strategy. Just make sure you put it in 3 times. Require them to respond within those period of time. If they don't, it's deemed to be a contract, a binding contract. That's where equity comes in. But nonetheless, on the other end, if you don't do that and you don't prove actual damage or loss of consortium, or the amount of time you spent working on those papers that you're using as, cause for strike and sanction, that they wasted your time, and you claiming the term as fees for all your time and energy that you spent traveling back and forth to do research, this and that, whatever it is. You can prove that, because remember, material facts, material evidence, preponderance of evidence, probative value, things with probative values are very important. So yeah, you still have to prove it. But if that's too much burden for you and you're moving for sanction nonetheless, cool. No need to do all that. You can leave it up to the court to make that decision, and it gives you the option here. And the court's initiative. On its own, the court may order an attorney, law firm, or party to show cause by conduct specifically described in the order has not violated 11B. You can leave it up openly, but nonetheless, your reasons should always still be there. If you know it's going to take too much effort, too much time to prove, the expense and all that, then leave it to them to do it. Just make the claim that it's wasting the court's time and the court's resource for the following reason, and then you mention all those things we've spoken of. Nature of sanction. A sanction imposed under this rule must be limited to what suffices to deter repetition of the conduct or comparable conduct. Meaning, the intent. Usually the intent of something, like when you create a trust, the intent will be there, or whatever it is you're doing, whether you're creating a law, it will tell you what the intent is. Whether you create a crime, which is what makes a crime, the intent. See how they speak? They put the intent all the way at the end, whereas honestly, it should have been right here at the beginning. But it's sometimes these things are written to just combobulate your head. So, but nonetheless, the nature of sanction is intent. The sanction imposed under this rule must be limited to what suffices. So the intent is to what suffices to prevent that repetition of the simulation of legal process, that repetition of the fraudulent conveyance of language, that repetition of vexatious litigation, that repetition of barrarty, that repetition of material fraud upon the court, etc., etc. That is what the intent is, by others similarly situated. The sanction may include non-monetary directives, an order to pay a penalty into court, meaning not to you, but to compensate the court for wasting their time. Meaning, if you cannot prove actual damage, or if you just don't want to prove that they wasted your time, because that's going to be more effort. People got shit going on in their lives. People got business to run, family, all that. So you can just leave it up to the court. And these people love making money, trust me. They love this. They love sanctions. Or, if imposed on motion and warranted for effective deterrence, an order directing payment to the movement of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation. And if you can prove it. Limitation of monetary sanction. The court must not impose a monetary sanction against a represented party for violating Rule 11b2 or on its own unless it issued the show cause order under Rule 11c3 before voluntary dismissal or settlement of the claims made by or against the party that is or whose attorneys are to be sanctioned. Meaning there has to be a show cause hearing, and they're basically not going to charge him money unless show cause hearing is done. Requirement for an order. An order imposing a sanction must describe the sanctioned conduct and explain the basis for the sanction. Everything we just explained thus far. Meaning preponderance of evidence. I'm saying if you don't have the time to show that you've actually spent that much time dealing with the crap that they brought, which you will make reference to, the document number, the page, all that, because if it can take it, this stuff is time consuming, then just leave it be and just leave the court to make the money on its own initiative. So sponte. Inapplicability to discovery. This rule does not apply to disclosure and discovery requests, responses, objections, motions under Rule 26 discovery, 237, basically discovery. So this is not applied during discovery, meaning they're dragging their feet to provide an answer for something. Even though really there's still loopholes within Rule 26 through 37, there is. There it is right there. You can move to sanction an attorney, or anyone for that matter, on wasting your time and the court's time. And you better have the evidence. You better know what you're talking about. So, and this is their loophole that they'll want to get out of. Keep that in mind. Best of luck. You got it. Go kick some ass.